terms of the judgment and order of the Honorable Supreme Court. Therefore, the source of notification is the Supreme Court order. Source of this notification is Supreme Court order. Read with order of 17th April in MA, so and so, has been directed to initiate fresh selection process to the post of assistant teachers, class 9, 10, secondary and higher secondary, and to the post of assistant teachers 11, 12. The Commission and Government of West Bengal have already applied for review of the state judgment and order, and this exercise is strictly subject to outcome of the review petition and guidelines of the Honorable Court to be followed by the Commission. This notification is issued for conducting second level, state level test for selection.
Mr. Bhattacharya, there is no confusion with regard to issuance of this notification in terms of the order dated 3rd April 2025, read with 17th April 2025. Now, this is the admitted position. Now, the situation is this, that if 3rd April and 17th April are to be heard, are to be considered together, in that event, there are certain directions given. You draw court's attention to that order.
Yes, I am coming. Yes, I am very happy. Now, kindly come to me, Lord. Page 91.
That is the order of 3rd April 2025.
This is the notification dated, my lord.
30
This is 30th of May.
30th May.
Page 1991 is the part of the notification.
Yes.
Now, kindly, my lord, note this. Eligible candidates.
Which part? Page 19?
By page 91, not 19.
91 plus 2.
2. Eligible candidates minimum qualification laid down in rules 225. Why do they get rule 2025 in connection with the Supreme Court order first? Then
eligible candidates with minimum qualification.
Apart from the
no minimum qualifications in rule 2025, which they have framed.
So that the selection is being undertaken in terms of the Supreme Court judgment. The Supreme Court judgment says that 2016 selection should be done.
Where it is said by the Supreme Court.
Kindly come to me, Lord. The Supreme Court order at page 84, 85. But before that, now it's my duty to place before Lordship the division bench judgment of this court, which was before the Supreme Court.
Division bench judgment, Mr. Bhattacharya, come to paragraph 363.
Yes.
363, sub-paragraph 2.
Yes.
All appointments granted in the selection process.
Yes. Now let us read Lord very carefully.
Yes.
363.
Read 363.
Yes. 362.
Roman 2. I.
All appointments granted in the selection process involve violators so and so and declared null and void.
Then straightway come to 9.
Yes.
11.
Yes.
11. Roman 11.
SSC shall undertake a fresh selection process in respect of the declared vacancies. These declared vacancies are not vacancies.
2016, 9, 10, 11, 12.
Involved in this 3 selection process, preferably within a fortnight from the date of declaration results of the ensuing elections. Then
13.
For,
then 13.
Yes.
The SSC shall follow the rules governing the selection process
in letter and spirit. Therefore, that rules which was prevailing with the division bench was not declaring this law, and that rule was challenged before the Supreme Court. Therefore, all things were that this is 2016 selection.
Where, Mr. Bhattacharya, it has been directed that new rule cannot be framed.
What the court says, that you initiate the selection process, the declared vacancies which were declared then, not new declaration, number 1. And number 2 shall follow.
Yes. The declared vacancies
governing the selection. Which selection?
Yes. Rules governing the selection. SSC shall follow the rules governing the selection process. Later. Whatever the rules are there, that is to be followed. That is to be followed. That is to be followed in the next selection process. Now the vacancies. Now tell me, if there are 1600, say if there are 100 vacancies in 2016 selection process for classes 9, 10, 11 and 12. Now in the meantime, if due to creation of certain vacancies, if vacancies are added, this cannot be taken into consideration.
Can I just, if your lordships permit me? Since your lordships have heard Mr. Mitro and your lordships have, if your lordship give me some time, I can clarify all these points.
I will hear you, Mr.
I
Bandyopadhyay.
understand.
I will hear you.
I will, these are the points I've already argued by Mr. Mitro.
No,
But
this was not a detailed
I
argument.
am not saying.
You are not there.
Whether at this stage of motion, there cannot be any details argument. If your lordship thinks that details argument, the matter is disposed of, I don't mind also. I don't mind also.
Allow me to hear,
No,
then
no,
I will hear.
I am
Yes,
saying,
I
I'm just saying.
I have that on basic prima facie issues. Therefore, this division bench judgment was declared at point of time, where the division bench said that
So according to you, Mr. Bhattacharya, first of all, the declared vacancies should be separated,
yes,
and a selection process is to be initiated in terms of the recruitment rules of 2016.
because these vacancies would arise because of the cancellation of appointment by the court. Therefore, the court permitted you to do it afresh.
Now, this order must with the order passed by the Honorable Division Supreme Court. Let us come to that order.
Kindly come to order now, Supreme Court at page 83.
Paragraph 45 onwards.
Yes. Last question, got it.
Conclusion under
Yes.
the heading conclusion 45.
The last question relates to the relief, which it requires, whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who are appointed must be terminated, and they should be required to refund salaries payments. Since their appointments were the result of fraud, his amounts to cheating, therefore we see no justification to alter. Then 646. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void.
This is for disabled candidate.
No.
46.
May I read it? Not specifically found to be tainted.
Yes. Yes, please read.
A selection process has been rightly declared null and void due to the egregious violations of the illegalities, which violates Article 16. As such, the appointments of those candidates are cancelled.
Yes.
However, the candidates who are all employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the entire examination process and results have been declared void. Then next week. 43 is not necessary.
Yes, it's not necessary.
Now, kindly come to 48.
48 is also
Not necessary.
necessary.
The disabled candidates mentioned in this regard, which
Yes, it is necessary. Please read 49.
okay, I am reading 49. My juniors will not insist to read 48.
Yes, I am also saying it's necessary. Yes, please.
Lastly, we address the case of the disabled candidates. Our attention has been drawn to such cases where impugned judgment had held the appointee, so and so shall be allowed to continue on humanitarian grounds. While
No, paragraph 49 says.
No, I was in paragraph 48.
48. Yes, paragraph 48.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee, so and so shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed. Then, the disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation.
Not other concessions.
No,
Only age
age
relaxation.
relaxation.
But in case of disabled, other
Very.
concessions and age
But
relaxation.
we are not here troubling the court with disabled candidates. In our opinion, such a direction would be fair. It would allow these candidates to take part in fresh selection process, which should now be initiated to fill the vacancies. Therefore, this is now being
Now, now I will ask you, Mr. Bhattacharya, where is the bar in framing separate rule?
first of all, don't say that they have no power to frame rules, but that rules will come prospectively. Here, the declared
No, in terms of the order of the Supreme Court.
Supreme Court always says, Supreme Court passes on at the point of time when the rules are prevalent.
Yes, but Supreme Court did not expressly debar the
not-
state authorities or the
question
recruiting
did not
authorities
arise.
from framing rules.
These questions did not arise at all. My lord will have to consider that when court is passing an order, keeping the law as it was then available. And when court found that the appointments of a particular selection is bad, court is permitting to do that selection afresh. If you do that selection afresh, you have to go back to that situation. You cannot come back later and bring something new. That would be really betraying the confidence of the court with the authorities. Therefore, 2016 selection should be made in terms of 2000 selections.
That is your submission.
That's my submission. And then kindly come to me, Lord. একজন বলতে দেবে আমাকে?
Yes.
Accordingly, paragraph 51, we uphold the impugned judgment cancelling our block entire selection process, but have made certain modifications in the direction issued by the High Court. The appeal at this was so and so. However, we independently take up the issue raised in filed by the state. That's a different issue.
Now come to 17th April order.
Now kindly come to me, Lord, the application filed by them before the Supreme Court.
And the 17th April order is German.
MA, kindly come to me, Lord, MA.
ওইখানেই তো আছে
briefটা দেখাচ্ছি, এই briefটা দেখাচ্ছি।
এই কেসটাতেই আছে পেজ 86
Lord, যে-
পেজ 86
EPT বলছিল হাতের কাছে রাখবে।
আরে অর্ডার তো এইটা
Come to order dated 17th.
But no order would be necessary. Let us see what are the application made. Copy through that. এত কথা বল, চুপ করে বসো তো। হয়েছে কোন application টা?
দেখাচ্ছে দেখা তো
কথা শুনি না তোমার। Governor kindly takes up the application. which was-
Application, that is miscellaneous application 709,
Yes.
taken out by the West Bengal Board of Secondary Education.
What was the application for?
Page.
My lord will find that application on the next matter. And the
देखिए
relevant-
next matter দাও তো।
Repeatedly বললেন application টা হাতে কাছে রাখো না। ওর থেকে দাও, দিয়ে দাও। একটু তৈরি থাকো না, যেটা করতে বলি শোনো। বিরক্ত নই।
Page applications next
Kindly
matter.
turn to that page, running page 188.
Yes.
So this is the application, also fine. This is the MA. They quote the order of the courts. Then kindly come to paragraph 4. They have again quoted the order of the division bench.
ওরা ওদের মতো লিখতে পেরেছে ওরা ওদের মতো বলবে আমরা আমাদের একটা বলবো কি হওয়ার কি
You kindly now come to paragraph 10. Pursuant thereto, a letter dated 22nd of April was sent by the Commissioner of School Education to all the district inspector schools in district, informing them about the order dated 17th April. Thereafter, the letters dated 23rd April were sent by the DI to all schools in the district, sharing a list of the assistant teachers who were not found to be specifically tainted. It is submitted that the names of the applicants do not find place in the said list. এটা কোন application দেখা যাচ্ছে?
But this is referring to 17th April 2025, Mr. Bhattacharya. We are on the order dated 17th April 2025.
Kindly excuse me, I am misled by my juniors, unfortunately. Kindly takes up the application filed by the board.
This court is on 17th April 2025 order
Yes, the 17th April order was passed.
on an application,
I am not.
but this cannot be
No,
that
No,
application.
no, I am extremely sorry.
Yes.
I am extremely sorry. My lord, the application is at page কোথায়? Because this application was filed by the copy দাও তো ওখানে by the state. এই তোমরা রেডি থাকো না, এত কিছু করতে যায়। But I just read out the relevant portion. It is stated that the page paragraph 5 of the said application. Steps are being taken in terms of the judgment for filling of the vacancies which have arisen on account of the, well, I can note this, which have arisen on account of the selection process having been set aside. The applicant is informed that a letter dated so-and-so addressed by the state government to the West Bengal Central School Service Commission issued. By way of instant application, the applicant most humbly craves to seek appropriate directions and modifications of the judgment to permit the appointed candidates not found to be tainted to temporarily continue in the various schools without claiming any equity in their favor until the end of the academic year or until the process for fresh appointment is concluded, whichever is earlier, so that education of these schools does not suffer. That's the application. Now, my lord, I do not replace the other paragraphs, which is not relevant. Kindly see what are the prayer made. Prayer was, permit the appointees not found to be tainted to continue in service till the end of the academic year or until the process of fresh appointments to such posts. Underline this, Lord. Appointment to such posts is concluded, which was earlier. On the basis thereof, the Honorable Supreme Court passes an order at page 86.
That is 17th April order.
Yes. We are inclined to accept the prayer made in the present application. Just
Yes, 17th April. Yes.
We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher of classes 9, 10, so and so, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts, no addition, shall be published before 31st of May 2025. Then the examination and entire recruitment process shall be completed by 31st December. These are the two things, Lord. Supreme Court says do it to those posts by 31st May and complete by 31st December. Until then, the non-tainted will continue and get this.
I permit you to read the rest of the orders. Now the problem is this: today, if court interferes with this selection process by making an observation or by setting aside this notification dated 30th May 2025, would it not lead to relaxation of time schedule fixed by this Supreme Court?
With deepest of respect, the court order is not to be observed only to maintain the time schedule. The court order has to be observed, and it is the duty of this court.
It is absolutely correct. It is under true letter and spirit. Now, but when with a default clause in 17th of April, this order was passed, then where is the scope left open to this court?
Yes.
To today, suppose hearing both sides, I set aside this notification dated 30th May 2025. Now that lead to relaxation of the time schedule or extension of time schedule by this court, that is according to this court is not open in view of the tenor of this court order dated 17th of April 2025.
But if your lordship finds that the first paragraph says advertisement for those posts is violated, will that be permitted? When the honorable court is really thinking in terms that I have to...
That is troubling this court.
No, the court has to set aside. The Supreme Court judgments are there. Article 144 comes into operation. This will be duty of the High Court to ensure that the Supreme Court order is followed. Here, my lord, in the name of following the Supreme Court order and to avoid the wrath of the court, they have issued a notification. And if that notification seems to be apparently illegal, would the court, my lord, feel shy of not interfering? We want, let the time schedule as such be maintained, but you correct your notification. This can even be done by collegium. We want that this Supreme Court order should be complied with.
Come to paragraph 3.
Yes. The state government, the applicant, West Bengal Board Education and the West Bengal Central Submission shall file their respective affidavits by 31st May, enclosing that with a copy of the advertisement for fresh recruitment as well as the schedule, therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published by 31st May and the affidavits are not filed, appropriate orders will be passed by this court, including imposition of cost. Now, to avoid this imposition, they have published a notification that have to first made. But is
Now-
that the notification?
Now, what is the effect of the order passed by the Honorable Supreme Court dated 17th April
Supreme
2025?
Court
That do this by this time, file an affidavit. So therefore, Supreme Court is still insisting
No.
of the matter.
So it's not sitting the matter. Supreme Court dispose of the matter. Kindly it comes to us.
Then what was the purpose of calling for an affidavit disclosing
That-
initiation of the
that-
selection process by issuing this recruitment notification dated 30th May?
To ensure that this is done. Otherwise, the application couldn't have been disposed of. Kindly see the last thing. The misapplication stands disposed of in the aforesaid terms. Court did not, my lord, keep any, my lord, control over the proceedings anymore. If it is to be done by my lord, independent application. Now today, I was thinking aloud that if the honorable court
Even Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
was by the state.
Yes. So
That's
then
why-
where is the bar in approaching the Supreme Court for getting appropriate clarification?
We cannot approach. And
But at the same time, the hand of this court is tied
No.
in view of the time schedule framed by
I
the
will
Supreme Court
satis-
with a default clause, Mr. Bhattacharya.
my lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think, court here sitting in the constitutional jurisdiction is my lord, also would be kind enough to consider
That a rule of law must be must prevail.
Supreme Court
Yes.
other directions. Supreme Court others directions in merit is not followed or not. Date is not only something which is directive. If the
But tell me whether this date extension of time can be
I am not
can be
asking.
relaxed.
I am not
Because
asking,
today we are in the mid of July.
even then.
Now, if I set aside this notification dated 30th May
No, I
2025,
don't say need not be set aside.
then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme
That
Court.
then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task would be,
So when you are approaching before this court, you approach the Supreme Court for extension of time.
why should you? I have to first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot straightaway go Article 32 petition filing a challenging notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court saying. Now, kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states, you follow recruitment process to that post.
Advertisement for fresh recruitment to be.
Therefore, if those posts,
Where which paragraph? Clarify that all orders and
now will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there's no difficulty. Even today, they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, where is the bar in the order?
Because under the rules, recruitment rules, you have to,
And how this can be restricted to the candidates of 2016?
because
Because that will in contravention of Article 16.
not at all.
It's a public
Public post,
employment.
the public employment for the vacancies declared. This is not a new process. This arises because of intervention of the court. Had the court not declared the selection was over, then these vacancies wouldn't have come. Kindly consider this.
But nowhere division bench and Supreme Court has said, Mr. Nowhere, that this selection process has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
That I will then again,
Nowhere it has
I
been
will
observed.
again invite your lordship to read the judgment in its entirety. But what was the issue before the court? Kindly excuse me without repetition. that 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were near there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this. Couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this first. These vacancies of 2016, 9, 10, 11, 12 are to be treated separately. And for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will again come back to the impugn notification. The notification is still inherently bad. And the Supreme Court, Milord, makes it very categorical that the tainted candidates would be barred.
Yes.
Prohibition.
That's true.
And you have allowed everybody to participate. Number one. Now, kindly consider the notice is inherently bad. Now, kindly, Milord.
Now, notification, I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate?
Right.
There is no such prohibition. And another thing I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provision
yes,
relating to allotment of marks,
I was going to say
now they are
inherently bad. You are
that is also. বলতে আমার এই ইয়েটা কোথায় ওই লাস্ট ইয়েটা দাও তো ওখানে নোট করা আছে
Oh, you have come ready. That's good. The marks.
First of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
distribution of marks.
Distribution of marks.
The additional marks for teachers comes. Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court. Distribution of marks. But that will also get blood in the rules.
Yes, that is in the rule. It is there. Yes.
Schedule 2.
Marking scheme.
At page 1110.
This prior teaching experience,
Yes.
whether 10 marks can be allotted,
Yes.
who has lost their job with the finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is below the open recruitment for fresh
10
recruitment,
marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11 and 12, how they will get
that
the
is-
marks?
you have correctly marked this. And then again, the distribution of marks was also changed
That I have seen.
to create another door for corruption. I use this expression with all restraint. Now you have seen these rules. Kindly come to this notification which is under challenge is of dated 30th May. And
Is there in the notification any provision that the tainted candidates should
No,
not
no,
be?
And this rule is published on 29th of May 2025. 29th May 2025 is the rule. And
30th
30th
May is the notification.
And there you say that we have additional vacancy in terms of 2025 rules. How could you arrive at the vacancy? If the rule was published on 29th of May and rule gives the detailed procedure for ascertainment of vacancies, how could you on the next day get the vacancies?
But I do not, Mr. Bhattacharya, find fault with clubbing of vacancies along with subsequent vacancies. If those vacancies are included, matter ends. But the question is, where is the embargo
When the vacancy is included, you are
clamped upon the untainted candidate, tainted candidates?
Lord, that is one part you have already taken note of. When you are adding the new vacancies, you are inviting fresh candidates. Just a minute. Now, Lord, you see the classification is so irrational. When you say that I add these additional vacancies, then you are inviting the fresh candidates who would be eligible today, and they will be putting in competition with the 2016 candidates.
Yes.
Is that fair? Apart from the question of distribution of marks, would that be fair? And when the Supreme Court and High Court says those vacancies only, because this is a fresh test of the persons who had participated. Today, they are thrown out. One group is completely banned, but another group is permitted that you participate and prove your worth. And if you now ask them to compete with the fresh students of 2025, that itself is illegal. That's why the rule says every year you have to assess the vacancies and publish the advertisement so that the fresh recruits can come and compete with the same vacancies. And clubbing of these two vacancies of 2016 and 2025 would be irrational and violate Article 14. You hold the examination separately for 2025. No problem. The fresh candidates will come and contest. Otherwise, you'll be putting us in difficulty, who are really the genuine candidates contesting 2016. Now, this notification, Milord, can even today be modified, corrected to respect the time schedule by the Supreme Court. 31st December, long way to go. Only this little modification that the portal is such that who have already crossed 40 years, they are not permitted to file. Though the Supreme Court says age election should be given, the notification says the age relaxation as well Supreme Court. If I am not allowed to enter, how would you assess whether I am age bar or not?
Yes.
Therefore, my lord, if your lordship, my lord, just conclude, my lord, I will not take as prima facie case. The division bench judgment and the Supreme Court judgment, the court was always conscious of the fact that this 2016 should be done afresh. Nothing beyond that. Let them do it afresh. With the guideline, the Tainteds are out, and the age relaxation to the persons who had participated.
Yes, that is there in the order.
No, but portal does not permit me to enter.
Age relaxation, already there is a direction.
There is a direction, but not, I cannot apply. The portal says they were barred.
Overaged.
Therefore, the portal should also be, my lord, corrected. Now, my lord, I just cite one judgment, my lord, relating to Mayawati's case, where, my lord, the CBI initiated a criminal case saying that the Supreme Court directed. The court declared this is void. You cannot say this. When the court does not specifically direct, you cannot take the advantage of this. Take it out. These applications will not filed by the state or the West Bengal secondary education supported by the state. That will not be filed at case 249 in the matter of 12512.
Paragraph?
Yes, just. Now, this is 2000.
12-8 SSC.
তোমাদের জন্য কাজ করা যায় না 2012 HSC Yes. The bylaw will find out in paragraph 14 stand of the CBI that why did they do so. Now the Honorable Supreme Court will not really frowns upon them and says you cannot do this. Paragraph 40 and 41. And 43.
It isn't the
Citation?
Paragraph 44 conclusion says, in the light of the above discussion, we hold that in absence of any specific direction from this court, in the order dated 18 September 2003 or any subsequent
paragraph
order,
40.
44 conclusion.
Just a minute.
Well, those paragraphs are given the discussions and for 44 is the conclusion.
Yes.
In the light of the above discussion, we hold that in the absence of any specific direction from this court,
Yes.
in the order dated 18 September or any subsequent order, CBI has exceeded its jurisdiction in lodging FIR number so and so, the impugned FIR is without jurisdiction, and any investigation pursuant that is illegal and liable to be quashed. Because even in case of criminal cases, Supreme Court has intervened. That you cannot take recourse of Supreme Court when the Supreme Court did not allow you or did not mention anything about lodging of FIR. Here also, when the Supreme Court is very categorical, they fill up those vacancies and remove the untainted candidates, give the age relaxation. All these three criteria have been violated. And that too notice in the name of Supreme Court. Can you not set it aside? Let them do it afresh. Or my suggestion before the court would be that these things can be corrected even today. That will not take much time. The correction can be done within 48 hours. The applications can be invited, the process. 31st December is the last date for holding examination. If any difficulty, let them say that we cannot do it by 31st December. We will remain approach the Supreme Court saying, kindly extend the time. Because we are interested to get job. But these are my points.
I'll hear you last.
No, last means,
I'll hear you last. Let Mr. Mitro.
let me finish. I don't know. I have also other matters.
Because I have fixed matter after hearing you. After taking, after considering that you are available on this. So allow others to make submission in a short campus, and I don't think Mr. Mitro and Mr. Dhod will take much time.
Today it will not be finished.
We'll only add if we find that something.
Today will not be matter. Will not be finished. But after 12:30, I will not be available. Then in that case, your lordship.
No, it will be concluded. Yes. Wait.
I have to accommodate. Then just a minute.
Yes, Mr.
Coming for
Dhod.
2 minutes.
Yes.
With your lordship, just I am coming for 2 minutes.
What has made some submission that has
Yes.
I'm not disputing the board's power to make regulation. Don't define. Only my dispute is such regulations cannot be in violation of order of Supreme Court. On those provisions in the regulation, in the notification, which are in violation or amount circumvention of order of Supreme Court, that will void, because that will be inroad into judicial power by civil authorities. That is on that principle. I am going to give those instances. That Supreme Court has consciously made a reasonable classification into tainted, untainted. Tainted, fraud, untainted, no question of fraud. So, Lord, Supreme Court allowed some advantages to untainted, which are not allowed to tainted, namely continuation service, till fresh election. And Milord, now question is, this Supreme Court allow Supreme Court allowed the first election to be held? A participant will be whom? Who will be the participant? That kindly take the order of Supreme Court, paragraph 49.
এইগুলো সমস্ত সরিয়ে নাও তো।
The classification reasonable
Just a minute. Paragraph 49 of the order dated 3rd of April.
just no place.
3rd of April, just a minute.
That's order to the. In my petition house is annexed, but my lord have a same petition, same order which goes. This, the only thing I.
Yes, paragraph 49.
49. Well, can you see me, Lord? The Supreme Court has treated tainted and untainted as unequals, not as equal. So the unequals cannot be treated equally by the board. That will violation of Article 14. Which unequals are treated equally, that also violates Article 14. That's not perhaps the mistake they have made. Now, who are allowed to? I accept the argument of Mr. Bhatta that this fresh selection process to fill up the vacancies as declared in 2016. Accept. Kindly now come to paragraph 49. Who are allowed to participate in the fresh selection process to fill up those vacancies? Disabled candidates mentioned previous paragraph will be allowed to participate in the fresh selection process, comma, if required with age relaxation. Then similarly, other candidates who are not specifically tainted will also be eligible to participate to appropriate age relaxations. Only not tainted. Well, tainted are not being allowed by Supreme Court. Supreme Court allowed only two categories of person to participate in the fresh selection process. One is disabled, section paragraph 48, and untainted. And even untainted will get the appropriate age relaxation, not others. In order
And
to
also
get
open category candidate,
where the
Mr.
just-
Mishra, also open category candidates. Those who did not participate in 2016,
those who-
why their right will be infringed?
that is, I'm not on that. They can make a separate rules. I'm not
Yes,
disputing the rule be struck down. I'm
yes,
saying only those provisions, and I point out those provisions, about 3 or 4 provisions, which do not tally with the Supreme Court direction. That is not. This is the Supreme Court allowed. There are two things. The vacancies which have appeared occurred thereafter is different.
yes.
But on the date of 2016 elections, there were declared vacancies.
Yes,
And this specific selection process is confined to that. Is vacancies as declared in 2016, which are now fallen vacant because of Supreme Court order of annulment. So, my lord, in the light of that, in my humble submission, it was appropriate for my lord to observe. Can you see, my lord, I'm reading out from the judgment.
which order?
My lord,
Which judgment? Yes,
yes. In the, my lord, in the order dated 10th of June 2025, by this order judgment, and see the judgment that specifically observed in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, tainted candidates do not have the right to offer their candidature in fresh selection process. That lordship in fresh selection process, which was to fill up the vacancies. The additional vacancies, whatever they board do. If the board think it is proper or fair to give a prize to fraudulent candidates, they will do so. That is more. Because this is not, we have made a petition and to annex that as without that, and my petition, paragraph 8, copy it. And for my less convenience,
yes.
copy it. Can we come to paragraph? আমরা পড়ে নি যাচ্ছি ওদের judgment.
What is the case about?
দাও না, পেজটা বার করে দাও। And we are very,
Order dated 10 June 2025, give a copy to them.
yes,
Which
yes.
part of the order you have just read? Internal page?
Interpret that request. It's good to me. Judgment is true. Judgment of God can lead.
10 June 2025.
And it's a copy of among the bar code.
আমি কাগজটা লিখছি না, ওটা বলতে পারে না।
Paragraph number to bar code. Huh? Yes, you have got a copy.
Yes.
I learned it immediately. Down to page, there's no agitation. 1, 2,
Internal page of this order.
no marking in my copy. Sir. I have put it in my notes. May I mark it? Is that a mark or not?
আমি 10
No, I have no name. My legend will go on.
This is in case of upper primary.
You know, it could be which page, last but one page. Last but one page.
Last but one page, yes.
Third page.
Yes, last but one page.
Second page from the beginning. Or third page from the beginning.
Third page from the beginning.
Yes.
Yes.
Paragraph number,
First, second.
a middle paragraph. First, before considering this. Got it?
Third page from the beginning, third page. Now, which paragraph? First, second, or third?
Second last paragraph.
Second last paragraph.
First,
Another limb of submission.
issue. First, it begins, first before considering the issue raised in the writ petition, this court needs to find out whether the petition is untainted candidate or not in connection with the selection process of first objection. Since, reason for this is, since in terms of judgment of the Supreme Court dated 3rd April, tainted candidate have no right to offer their candidature in fresh selection process. That was the reason. And because I'm humbly supporting the judgment from paragraph 49 of Supreme Court judgment order.
Only two categories, disabled and
And
not specifically tainted or untainted.
this is my support of my judgment. This will come to this anyhow now
Yes.
is one thing.
Yes.
The reasonable classification made by Supreme Court
Yes.
cannot be obliterated by board or anybody. No, anybody. Or the unequals cannot be treated as equals. That's Bhalat. This is my point. Second point is not number of vacancies in the post as directed in 2016 cannot be 2000 rules or 2016 to 25 seal process be reduced. The vacant posts which are declared in 2016, now that has to be filled up by fresh selection process. That cannot be reduced. Which has been sought to be done in this case. This theatre. Theatre. Look, may I have, and we might as kindly look at what the list made, and they have annexed a supplementary affidavit. If copy of
এখন আমি কি করবো? এখন সাপ্লিমেন্টারি এফিডেভিট এত বড়, what I will do? What I will do with this supplementary affidavit at this stage now? Now handing it. No, read this. I am not very intelligent. I am a dull-headed man. I need time to read.
No, I'm trying to. I'm only relying on a list of.
Now, Mr. Mitro, as the last occasion, I also asked you
Very good, but
that
But in that case, your lordship is direct for filing an affidavit.
last occasion I also
Lord, you can give.
We'll file
last occasion I also
so
asked
much
you
arguments are there.
asked you that in terms of the order dated 17th April 2025, that is
I'm only seeking this direction from you, my lord. The posts which are vacant
Come to the order dated 17th April,
17 April. No, that's the order of
Supreme Court,
the modification order.
modification order.
Which number can actually expert? And I'm going to ask you to wait.
Same question I would like to ask you also.
Yes, please. Yeah, one second, the top. How much? You don't need. Correct. Yes, sir. Thank you. Thank you very much.
Modification application 709 of 2025, order dated 17th of April, first.
Page 131 আমি আপনি খুলে দেবো
Yes. First paragraph, an advertisement for fresh recruitment to the aforesaid post shall be published before 31st of May 2025.
That has been done.
Then the examination and the entire recruitment process shall be completed by 31st December 2025.
Yes.
And more striking is the third paragraph, which is and fourth paragraph, that the state government and the application West Bengal Board of Secondary Education and the West Bengal shall file their respective affidavits by 31st of May 25, enclosing
Yes.
the copy of the advertisement
Hmm.
for fresh recruitment as well as schedule therefore, so as to ensure completion of the recruitment process.
Yes.
Then in case the advertisement is not published by so and so, the default clause. So in view of this, today accepting what Mr. Bhattacharya and you have submitted, or other learned advocates representing the petitioners submits, if considering this, if this notification, recruitment notification dated 30th May 2025 is set aside, in that event,
No.
does it not lead to relaxation of time,
That's why
which has been fixed by the Supreme
that's why without submit, I don't want, I am not submitting for cancellation of either of the 25 rules or the notification. I am saying only those provisions therein which are in conflict with the order of Supreme Court, direct the board not to enforce those provisions. I have given one provision, I'm giving my lord. Second provision giving that listen a minute. The order of our division bench was paragraph 363(11), 363(11), which have been confirmed by Supreme Court. Our page 93. You undertake fresh selection process in respect of declared vacancies.
paragraph division bench order.
Division bench order, which has been confirmed by Supreme Court.
Yes.
Supreme has confirmed the order. Only time has been modified. Instead of 14, by given time. So we not only have this direction, and no question of any
Supreme Court has modified with the time schedule.
only time schedule.
Now, if this time schedule, whether this it is open to this court to relax the time schedule.
No. Certainly, we not. It's for Supreme Court relaxment. I'm
Yes.
not asked for any. That's why I'm asking. I'm not asking for order of cancellation or notification or
Yes.
cancel the initiation of selection process. I'm not asking for that. I'm saying this selection process we have started, all right, but that the posts which are declared vacant in 2026, they know
That has to be taken into consideration while
that
initiating
cannot be
selection process.
reduced by abolition of anything else. That is the only direction. At least make that direction. That will not affect the selection process. Allowing or disallowing
And the two categories of,
363.
only two categories of candidates are to be permitted to participate.
Yes, number one, direction. Number two, the vacancies were declared in 216 election process. Those posts cannot be abolished or reduced. If they are posts, that's post. And I've given example of such posts in a list which board knows, etc. I've given in my notes also. I have mentioned that illustrative text, then explanation is given.
Yes.
This is second direction. Third direction, I'm asking from your lordship upon the board that any age qualification of candidates for selection of 2016 as per 2016 notification and rules can be relaxed only in respect of untainted successful candidates. If Supreme Court says, my lord, should be allowed age relaxation in paragraph 49 to only two disabled candidates and tainted candidates. Sorry, untainted candidates. So now this age qualification cannot be relaxed in respect of tainted candidates if they appear or any other candidate. If they appear
Yes,
for
yes. Question of participation of tainted candidates in view of the observation and directions contained in the order
Yes.
dated 3rd April 2025 does not arise.
Yes.
That is
the one thing.
That is clear.
And there may be other candidates who had not at all appeared in 2016 selection process, but new candidates may come in. But don't allow age relaxation to them. So far as the specified declared vacancy of 2016, I'll make it clear. Declared vacancy to 216 vacancies are concerned. For filling up those vacancies, board cannot change the age qualification as given in 2016 selection rules, namely minimum 20 years, maximum 20 years, as on January 2016. January 2016, which board is now purporting to make minimum copy it.
Yes, Mr. Mittu.
Oh,
this is
just
the
been
Sagar-
down. Yes.
So
which
the
have been-
vacancies which are earmarked for 2016 selection process
As
cannot
on.
be open to other category candidates. Yes.
So it
This-
must be minimum age 20 as in
This is
January
up to the
2016.
yes.
No, 16. That board cannot now make that minimum 20 or maximum 40.
That is so on this point, Mr. Bhattacharya also argued
Yes.
that these vacancies are to be kept separate for
Yes,
2016.
that's applied.
So I lost that.
Okay. Now what they're doing, Milord, they're making the age qualification minimum 20 and maximum 40 as on January 2025. They're giving 9 years age relaxation. And that the new selection, but that should not be given. Now making 9 years age relaxation, minimum qualification 20, 20 and 40 was as on 2016 January. Now they are making it as on January 2025. That is in violation of order of Supreme Court.
But Supreme Court directed to give age relaxation.
My lord, that in respect of declared vacancies, that age qualification cannot be relaxed. If the other vacancies are there, let them fill it up in the proper as per rules. I'm not saying rules is altered is what, only pointing out some provisions which are in circumvention order of Supreme Court. I am pointing out only one, the clause page 1. No, page 1. Lordship have taken my petition.
Yes.
My petition, page 144 of my petition, Lordship get that. Educational qualification, including the age limit.
Yes, page 144.
This one. This is age limit of defined, minimum 21 years and maximum 40 years, as on 1st January of the year of publication of advertisement, that is 2025. That publication advertisement 31st May 2025.
So, but minimum 21 and maximum 40 is the normal procedure for that is the normal age.
Correct.
That remains. But what is the age relaxation given to the untainted candidates?
My only submission is because now Supreme Court order is fill up the declared vacancy of 2016, and in so far as for directs was filling up the vacancy of 2016, the age qualification should be as on 20 and 40 as on 2016 1st January, and not 21st January, 20 January, 1st January
For the candidates of 2016.
2025.
That is your plan.
Yes, I'm only concerned declared vacancy.
Yes.
And not in my petition, I should get that copy of the previous, what was that age and what. No, my lord.
So age to be considered with effect from 1st of January 2016. Yes.
And the last direction, I'm asking, last direction.
Yes.
Now Supreme Court has said,
One thing I just point out, Mr. Mittal, let Mr. Mittal submit whether he is asking for that is total, this notification should be.
no, I'm not asking for.
Ultra-virus or not?
No, I'm not.
No, please. Prayer A is that. Prayer A is that. Let him record that, that's whether he is pressing for it or not.
No, let's record it. I'm not.
Prayer.
Prayer B, actually. Prayer B, I'm not in.
Let him
Right.
pray first, this prayer B, he is not
I'm saying,
pressing.
okay, let's record that.
Then one of the party is not pressing prayer B.
Yes, correct.
Then other alternative prayer comes.
Huh. That's right.
Very good.
I'm already submitted.
No,
Yes,
no.
can you record?
In the morning said that
agree.
Mr. Mittal has also fought for.
Yes,
Declaration.
very good.
That is ultra-virus.
That is there in the prayer.
Can you record? Can you record prayer B? I'm not pressing for. I'm asking for. The last direction I'm asking for, last direction
Yes.
upon the board is that Supreme Court direction is very clear that untainted candidates will be entitled, eligible to participate in the fresh selection process for filling up the vacancies of 2016. Correct? No qualification is necessary for that. Now, what the board has given a direction, the marks, the qualification marks in under 260 regulation was 50 marks in academic. And in the 2016 election, the qualification marks were 45%. By getting 45% marks in academic, there have been many candidates who are allowed to participate in 2016 election process and be successful in that also.
So therefore, you are also questioning this fixation of minimum qualification 50%.
Minimum qualification
Yes, yes.
insofar as filling
It
up
have been 45%.
vacancies of 2016. I have prepared a humble note.
Yes, yes, you have submitted this note.
Yes. That is not an that's
Yes, if anybody wants to add anything,
I'm not.
yes, don't take much time.
There is.
Wait. Yes,
Give me a second.
yes, I'll give you. Yes, I'll give you. I'll give you.
Absolute, absolute zero. Absolute.
I will give you, Mr. Bandyopadhyay.
That was a part and matter. I requested you to put that.
I'll give you. I'll give you.
There-
Anything you want to add? Yes.
My path would be a middle path. I would not
Yeah,
be
may I take
making
minus kindly?
submissions of either of the extremes.
That I'm making clear,
What
but
I'm
I'm not.
saying is this. Well, usually in statute, we have a clause, a super clause, which can override others, which is not available in case of a judgment of the Supreme Court. So therefore, harmonization is required to be done by your lordships if situation arises.
But where is that
So I'm
scope left open?
I'm coming.
In view of the time schedule.
I'm coming. So therefore, I'm not saying
One thing, it is directions which I'm asking, only the report directions. If that is if direction is given, and with a board thing, because of direction,
Yes.
it is not possible to complete within.
No, we are not thinking, we are supporting this. We are not.
Then,
We are not thinking that.
then
We are fully
we
supporting
can
this.
jointly
No,
apply.
not-
Then,
It's orders and
so
orders.
will
We are
understand
not thinking.
that these directions will not
No, we are
require
not thinking.
will not
There is
require
no-
extension of
there is
time.
no use of wasting time on that point.
Yeah.
We are not thinking. We are supporting it and we want to see that the
Yes.
selection is done in terms of
Yeah.
this. Finish.
Those directions will not
Unless
this,
my lord declares that this is a ultra-virus, that's a
no,
different.
no, I'm not saying.
No, that's a different thing. Others will proceed on this.
Yeah.
We are not thinking at all in a
No,
different way.
This both direction will not call for extension of time. That's
No,
very
no.
clear.
well,
May I take it?
I was trying to harmonize, and I do agree with lordships.
And
Prima
also
facie,
I want to point out to your lordship, there is another article. And content petition pending with this. Let me inform you, but nothing more than that. That doesn't mean that I will not argue.
Yes.
well, I would begin with
Supreme Court may say, no, we are not in go to High Court.
And I would begin with,
Or
I completely think that that would be the first and prima facie, my lord, the opinion that Supreme Court in season of the matter. Absolutely, because that's the expression. I understand that. Now there are two things. One is, this notification is good or bad, set aside or keep it as if it is absolutely perfect. This is one. Other is, there are some irreversible situations, like in the notifications, the last date of form fill up is 14th. There are number of situations where, because of the last date being 14th, many of them, they are disqualified. They were qualified under 16. Some posts where they are now found to be not there, so they will not even able to participate. All I shall be praying today and an interim order without affecting any of the honorable Supreme Courts. Now there is a vacation. Supreme Court, honorable Supreme Court will be reopening on 14th. I would be only seeking, because I don't want your lordships to enter into the entirety of the matter, because it will cause lot of time, lot of intricacy of laws, and I cannot make a very biased interpretation. Both sides have their things to say. But till that time, kindly extend the form fill up. Supreme Court has got said nothing on that. Kindly come to the MA order. Paragraph 3.
17th April.
Yes, 17th April. Because if 17th April stops your lordships and lordships cannot.
Understood. Yes.
Kindly see paragraph 3. Before that too, the examination and the entire recruitment process shall be completed by 31st December 25. This cannot be tweaked by your lordships. It is watertight. Cannot be. 3. State government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 25. Cannot be tweaked. Enclosing therewith a copy of the advertisement for the fresh recruitment, cannot be tweaked, as well as the schedule, therefore, so as to, kindly mark this, ensure completion of the recruitment process. This also cannot be tweaked. Now, 4. In case the advertisement is not published by 31st May 25, cannot be tweaked. And the affidavits, kindly look at it. And the affidavits, so it's a document itself, not about.
Are not filed by that date, the appropriate order to be
Exactly.
passed.
So therefore, lordships cannot.
For according to you, 31st of May cannot be relaxed.
Yes.
31st December cannot be
Cannot be.
relaxed. But a date can be relaxed.
All I'm
But there's a
praying,
problem.
I'm saying, all I'm praying that there are multiple problems which are fundamental in character. All I'm praying, kindly extend the date of form fill up by 1 month.
If I extend the date of form fill up from 14th July
Yes.
to 14th of August,
Yes.
in that event,
Yes.
it's a huge process,
No.
Mr.
Kindly
Dhar.
see the
That
irreversible
from
effect.
14th of August to 31st of May, 31st of December 2025,
Yes.
it may not be possible for the commission to complete
Right.
the recruitment process.
But there comes the clause and the super clause. I say that lordship is seeing these directions of the Honorable Supreme Court as super
So court
clause.
has to proceed taking into mind that the Supreme Court has fixed from 15th of July to 31st of December 2025 being the date
Yes.
by which School Service Commission has to complete the selection process.
Correct.
If that court accepts,
Yes.
then it is not open to this court to extend the time for filling up for submitting the forms.
My lordship has ample power. The reason is this. This is one part of the Honorable Supreme Court order. There are other parts of the Honorable Supreme Court order which entitles me to participate. Now, large number of participants.
Any other submission, Mr. Dhar?
Malad, the irreversible effect is this. Kindly have a look at the irreversible effect. That my supplementary 1 page, page 17. This post is not even there. I've given the list.
Yes.
45%. Earlier it was the eligibility. Now it has become 50%. I won't be able to. So all I'm trying to say, there are other part of the Honorable Supreme Court judgment that has to be adhered to. There are this part of the MA order that is also to be adhered to. This now, while adhering to the time, can the other contents of the Honorable Supreme Courts by which I was entitled to participate, can that be taken away? I said, Lordship, do not answer finally. But kindly look at the liberal view and the narrow view. The liberal view would be if Lordship extends that, nobody dies in the meantime, when the matter is decided. Because otherwise, 14th is last date. None of them would be able to participate. So no matter what,
Any other?
this is, and as far as the contempt jurisdiction, my lord, that is a completely different purpose. Because there is a judgment of the Parihar, paragraph 6.
But I have given reference three judgments. I have referred to in my note for the well-known proposition that legislator cannot make inroad into judicial power without taking away the basis of the order. For that, I am not referencing
Well, this
three
is the
judgments. I have
paragraph,
given the reference to my lab.
paragraph 6.
Yeah,
classicum-
1970 Supreme Court 1292, then 1974 Supreme Court 1232, and 1995 6 SCC page.
What is the proposition? What is the proposition?
In a note I have mentioned paragraph 5 below. So it's unfair on my part not to apply.
Can you tell me the proposition?
Yes. The paragraph 5 I have noted. AIR 1970.
No, what is the proposition of law based on which you are citing this
on
judgment?
the question that this any order or subordinate legislation which is in violation of order of court is ultra vires constitution because taking inroad into judicial power without removing the basis of the judgment. Paragraph 5 also find that. And not I'm giving my hand. And take it, no. I hand paragraph 5. Last paragraph. Last page.
Yes.
And I have handed back my notes of submission to my learned friend, Mr. Bandyopadhyay, for his concern. So everything I'm putting on the table.
This is the judgment 96.
No hide and seek.
This is the judgment of J.S. Parihar,
Yes.
96, 6 SSC 291,
To my lord.
clearly saying, if I can read two sentences, the question is whether seniority list is open to review in the contempt proceedings to find out whether it is in conformity with the directions issued by the earlier benches. It is seen that once there is an order passed by the government on the basis of the directions issued by the court, there arises a fresh cause of actions to seek redressal in an appropriate forum. The preparation of the paragraph 6 placitum, my lord, around G.
Yes.
And I say that,
Yes, Mr. Bandyopadhyay.
I say that there is a requirement of the
Anything you want to add?
Kindly just let them add it below after my just kindly. But I thought it one item against I will argue. One item I will then the one first Mr. Vikas Bhattacharya I have to argue. Then two somebody will take point. I have to argue.
You have to finish with one sentence. There is a requirement of the new rule because the SSC is required to change the waymark, which is the cause. Now they have made it preservation rules. There are several rules which were the reasons for quote and unquote corruptions.
Very
So
good.
therefore, I do think there is a need of a change. No doubt about
All
it.
these lawyers have appeared on behalf for the corrupted peoples before the on another bench.
I think allow
Now
me to say,
this-
Mr. Your turn will come.
Ah.
So therefore, I say there is a need.
You are arguing in my
Yes,
turn.
he will complete. Mr. Bandyopadhyay, please take your seat.
You are arguing in
That
my
there is a
turn.
need because otherwise old rule which was found to be incorrect destroy the OMR that had to be changed. I also feel number of increasing vacancy administrative matter, nothing wrong about that.
Yes, that
nothing
is
wrong.
also the view of this
There's
court.
nothing wrong about that. And I feel that
But those vacancies must be clubbed.
those vacancies can be clubbed, there is no difficulty. But all persons who are eligible to participate in 16, they should not be barred.
Excepting
Yes,
tainted.
excepting tainted. Now, tainted, my lord, I read and found possible two views. Two views are possible. Though I'm going to say tainted should not be allowed. That's my view. I'll try to support that. But that would require a lot of time ultimately to come to a conclusions. So might be Honorable Supreme Court. But till that time, my honestly request before lordships, kindly ensure that no irreversible effect happens. So if the form fill up, which has not been touched by the Honorable Supreme Court, if that time by 1 month is
That
extended,
you have submitted, Mr. Yes.
Maroda, Maroda, kindly, otherwise, Maroda, I will not be able to. Kindly, some, Maroda, some kindness to kindly show to me, Milord. Some kindness kindly show to me, Milord. Item,
I will hear you.
Milord,
Mr.
I have
Mukherjee.
other matter. I thought it item one, your lordships will give me the answer.
Give importance to this matter.
No, no,
Mr.
that-
Bangopadhyay.
it's all right.
You know the
I am not,
outcome of this matter.
I am
You know
not,
very well.
I,
So therefore, the lawyer.
I am not saying so.
Should give some importance to this
Absolutely
matter.
correct. But so far item one, when it is happened, then item one, I will
Let your
give the
junior
answer.
argue in that matter. I will hear you in this matter. Yes. Please take your seat.
Very nice.
Accepting Mr. Bhattacharya's submissions from paragraph 7 onwards.
11 matters have come together.
There was a time fixed by the Honorable Supreme Court. Here, in the judgment of your lordship. This is your lordship's judgment. Paragraph 7 onwards. Your Honorable Supreme Court fixed the time limit. No, that's not this another matter. In parliament. Within
That primary matter.
exactly.
In IOS.
Now, your lordship said that they should be allowed to, if situation arises, parties will be at liberty to approach the Honorable Supreme Court for extension of time.
Yes.
The extension of time is not a matter. The second submissions I tell your lordship. So for the main judgment, your lordship, that substantially defines and concludes the right of the parties. And the last order, your lordship, only the procedural.
But in
part.
that judgment, I have not extended the
Now I
time.
tell your lordship, what happens? Because of new rules.
That is a situation where court has held that NIOS with DLA a similarly circumstanced candidate, but they are not the appellants before the Honorable Supreme Court. So therefore, they are to be considered separately by submitting their credentials, their eligibility to be
But that,
considered.
the time limit was that only the appellant to be appointed by 31st.
That was in connection with the appellants only.
That's your lordship. That's why I could not complete with that. Here the situation arises. because your lordship-
So far 2016, 19, 11, 12, there is no division. Only all the candidates case are before this court. Now Supreme Court has specifically said that by 31st May you have to initiate
complete the
proceedings,
appointments of appellants.
and by 31st of December you have to complete the process, 31st of December 2025. Now if this is the specific direction of the Supreme Court with a default clause directing the authorities to file an affidavit disclosing the recruitment notification, failing which an appropriate order should
They have issued the recruitment
These
notification.
are different ramifications, Mr. Shannan.
According to me, it's not that. If there is any default clause of the Supreme Court order, if ultimately found by your lordships that this is a violative of the rules and the Supreme Court order, they have to go before the Supreme Court and say, because of this, you extend the time. This is the court of the order of the Constitutional Court.
So
That was the same
that
situation.
you
in the
also approach the Supreme Court praying
But
for
they
extension of time.
will approach your lordships in our matter directed. The board will approach
Yes,
for extension of time if the consideration cannot be made.
very well.
Second, your lordships, both the petitioners in item number 8.
Yes.
Now, both the petitioners are in earlier round of selection process were selected. They were serving. One in English, one in political science. Now, because of the new advertisement, they are not entitled to be appointed.
45%, 50%.
This is one point. Now, your lordships kindly consider this judgment of our High Court. This is reported
Nil Madhav Das and others versus State of West Bengal and others. Your losses here, your losses might remember this situation where two selection process was clubbed together, 2005 and 6, by an advertisement in 2009.
Yes.
This High Court interfered with this situation. Your losses kindly consider page আমি দিয়ে দিচ্ছি তোমায় কপিটাই দিয়ে দিচ্ছি 2005 page 5. Kindly see these are the points. Controversy, number of vacancies different, year of vacancies different, category of vacancies different, date for calculation of qualifying age were different. Now your losses will find next your losses page 11 why the single bench orders were affirmed that two vacancies cannot be clubbed together. Page 11, the second paragraph and third paragraph. Third paragraph, fourth paragraph. The qualifying age in respect of recruitment.
Third paragraph and fourth paragraph.
Yes, without number.
Yes.
The qualifying age in respect of recruitment process initiated pursuant to the requisition dated 2005 was different from subsequent recruitment process 2006. And then in the aforesaid section, the candidates in respect of 2005 recruitment are separate in every respect from the candidate sponsored by the subsequent requisition. The advertisement means they will re-advertise the vacancies already declared. They cannot include the subsequent vacancies. They are governed by the subsequent rules entirely. These are my answers.
That is the submission of Mr. Bhattacharya.
Exactly, your lordship.
So the separate
That to be considered.
অনেক সামনে একটু অনেক করেছে একটু বস এটা আমাকে একটু শুনতে আরে 2 মিনিট একটু
Yes, Mr. Bandyopadhyay.
হ্যাঁ
Yes, you start.
my lord kindly see I just tell you lord এবারে now my turn my lord kindly see you will give the answer you will
I will hear you later. Yes.
my lord kindly just I take your lordship from the very basic thing. Let us tell your lordship the facts. There was a selection in 2016. Now in selection there is a panel.
You are representing whom?
I'm a SSC. Panel is prepared. Who are unsuccessful? Those whose names are not in the panel. Correct? In the panel, those names were their panel. High Court directed to make a CBI inquiry. Right? From there, tainted, untainted categorization have come. These dual disqualified persons, in their cases, it has not been done.
Yes, this.
These disqualified persons, whether tainted or whether untainted, nobody knows. What has happened? Ultimately, entire selection process is gone. Their selection process is gone also. Those who are selected, their selection process have gone also. Therefore, all selection process has gone. What the Supreme Court has done, all appointments are set aside. First order. I'm coming later. All appointments are set aside. Whether tainted would remain or untainted, all appointments are set aside. What is the consequence? Nobody in the employment from the selection. Selection process is illegal. Whether unqualified or qualified. Their cases are not scrutinized, their cases have been scrutinized. Selection process itself is set aside as tainted. Selection process has been set aside as faulty. No right to them, no right to others. On the date of the Milord, first date of the judgment, that is that is the page. 3rd April, Supreme Court judgment. Let me read the judgment. That will give. Milord, kindly see the 3rd April judgment. What page? আমার এখানে দাগ দেয়া আছে দেন না kindly come to paragraph first 75. Milord, it has been set aside, etc. It has been shown to you, Lord, so I don't need to require to show. All have been set aside. Now, your lordship, kindly come to first paragraph 70. আরে ভাই তুমি দাঁড়াও না ভাই তোদের এক দোষ হয়েছে ওখানে হচ্ছে শামীম আর এখানে হচ্ছে তুই
Yes, yes, Mr. Bandyopadhyay.
kindly come to Milord, page first 46.
Paragraph 46.
Yes. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violates Article 14 and 16 of the Constitution. As such, the appointment in these candidates are cancelled, all cancelled. Selection process is gone. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the examination process and results have been declared void. This is the order. No candidates can be appointed on the basis of that selection. Whether it's unsuccessful, whether tainted, whether untainted, no one can be appointed from that selection process. Not future selection process. Not future selection process. From that selection process.
How you are submitting this? Come to paragraph.
I just give me time. Give me time.
No, because we have to consider it in the light of the order.
I am coming, sir. I am coming. Just give me time, sir. Kindly, give me time.
We
madam.
cannot attribute our own interpretation.
No, no. I am saying, I have my submission.
Yes, yes.
I have my interpretation. Your lordship may accept or may not
The
accept.
court can ask Mr. Bandyopadhyay,
Yes,
again
yes.
for SSC, that if this submission is found to be in teeth with the order of the Supreme Court.
Absolutely. I am coming. I am making first this judgment's first interpretation. I am saying on that date, I have started with the submission on that date of the judgment has been delivered. Therefore, on that date, everybody should go.
Yes.
And that I am submitting. Possibly I was not clear to your lordships. On that date, now kindly come 47. Take to 47 paragraph. Come to 47. Some of the appointed candidates who do not fall within the category of the tainted candidates, kindly see, may have previously worked in different departments of the state government or with autonomous bodies, etc.
That is not relevant.
In such case, all their appointments are cancelled. See, cancelled. But the candidates will have the right to apply to the previous department or autonomous body online in service because their continuity in service. Paragraph 47 is specifically for
Some of the appointed candidates who do not fall within the category of tainted.
correct. Those who are working in other department, they will go there and
Repatriation was allowed,
there and
even necessary by creating
supernumerary and their continuity service has not been disturbed.
interfered with, right?
But
That is confined to tainted candidates. And
they are untainted. I am saying that is an
Yes.
untainted. This benefit has been given by the Supreme Court. Then kindly come to Miller, paragraph 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concession. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Kindly read this line. Only for the untainted candidates there would be age relaxation. But untainted candidates will not be appointed. That's not there. Tainted. So for the untainted candidates, age relaxation will be there. Age relaxation will not be for any other candidates excepting the untainted candidates. This sentence doesn't mean that tainted candidates cannot make application without any age relaxation, or this had not been made for the candidates which application can be made, even the who are unsuccessful, where selection process has been set aside. Kindly read this.
Similarly, other candidates who are not specifically
In our similarly, other candidates
who are
who are
not
not specifically
will
tainted
also be
eligible to participate with appropriate age relaxation.
Yes.
Participate.
Excluding tainted candidates.
No. No, my lord. No.
Yes.
But this is our.
That cannot be a clarification.
My lord, that is.
That clarification I didn't expect from Mr. Bandyopadhyay.
No. This is my
Yes.
clarity.
Yes.
This is clarification.
Yes, Mr. Bandyopadhyay, I am eager to get an explanation from you.
No, no.
Which is
My
found
lord,
to be
your
genuine.
lordships may not accept, but don't be annoyed.
No, I am not annoying.
Don't
I am
be annoyed.
Also expressing my mind
No.
so that you can respond.
Yes, all right, but not with annoyance.
No, not at all.
And not at
But
them.
I am also seeing your annoyance not being permitted to make an argument within time. From the
Not being
morning.
permitted to do.
Yes, you are saying that from 12:30 I have other matters. Allow others to.
Why
argue,
you
Mr.
are mixing up
Bandyopadhyay.
all these issues? Then you could have taken it. I am stopping it.
Because
If this-
accepting your submission and your request, I fix the matter today.
Correct. I am not saying so, but I expected also item 1 is finished. Item 1 I will argue. But if your lordships will
All the matters, if separately matters have to
No.
also
If
appreciate the
this is
predicament of
this
this
is
court, Mr.
my lord, I am not come here to quarrel with
Very
your
well,
lordships.
very well.
I have not come up to
paragraph
quarrel with
that-
you.
No, why should
I am
you
not
should-
come.
You have
I am
come
not.
to a quarrel,
No,
but
no. My lord, I am
49.
I am a
your
very
paragraph.
I am a very small lawyer. Why should I quarrel with a great judge of Calcutta High
That
Court?
knows everybody that you are a very small lawyer.
Yes.
But
I
a
am
judge
very
is a
small
judge.
lawyer.
That
Great
judge
judge.
can
I
judge
can.
can
That's all
ask
right.
query.
Yeah,
or
of
make
course. I
query
am
to
giving an answer.
any senior advocate.
My lord, I am giving. I
That
am
is the beauty of our constitution.
that. This is
Now the
beauty,
thing is this, Mr. Bandyopadhyay, paragraph 49, your submission is this.
beauty of our constitution is
Yes.
beauty of our is this. If the judge does not accept the submission of a senior lawyer, then judge would become annoyed. This is not beauty.
No, I am not at all annoyed. This is a way this court generally responds.
Listen.
Yes. And at the same time, court also expects that there is no annoyance from
No.
from a senior advocate like Mr. Bandyopadhyay.
Why should I?
Because others
I am not.
are looking at you, they are learning from you.
My lord, I will not argue better.
Yes, please,
My lord,
please,
since your
please,
lordship
please
is
proceed.
making so
Please,
much-
please
My lord, my
proceed, Mr.
junior-
Bandyopadhyay.
No.
Yes.
No, I will not argue.
Please proceed.
Your lordship is making very caustic remarks.
Yes,
And
Mr.
never
Bandyopadhyay.
anybody has made such a caustic
Yes,
remark.
Mr.
No, my lord. I will not argue.
Court
You are a great judge. I will not.
court is eager to hear you.
No, go. You are so. I don't know. Days are changed.
Yes.
That much I can say. Days are changed.
So therefore,
My lord, kindly see.
yes.
My argument is this will also eligible to participate with appropriate age relaxation.
Therefore, your argument is this in a short campus with regard to paragraph 49 is this: those who are tainted, they will not get age relaxation. Those who are not tainted, those who are untainted, they will get the benefit of age.
Age relaxation.
That is your.
That is my
interpretation.
argument. That is my argument. And whole rule is based on this. It's an open category. Open category. Now, as it would above these candidates to
Just
take part.
a minute.
No, push no. Now, if you restrict it,
Yes.
my lord, kindly see, if your lordships restrict it, just for another view I am giving, if your lordships, then only untainted candidates can apply. Neither tainted, not the unsuccessful candidates.
Couldn't follow. Yes, please repeat it again.
Let's assume that your lordships, if your lordships says only untainted candidates will apply, then in that case, my submission, interpretation has to be given. Neither the tainted candidates can apply, nor unsuccessful candidates can apply. Though otherwise eligible. Kindly appreciate this. That is the reason I have started with this. See, the inquiry was only for the panel candidate. Inquiry was not there for the unsuccessful candidates. We do not know who are tainted or who are untainted amongst them.
But is it required to enter into the this issue after the order passed by the Supreme Court,
After the
specifically prohibiting tainted candidates from participating?
Moral, I am submitting. Here is no prohibition of any other person. No person is prohibited to make an application. My lord, this is my submission.
Now, your submission
Um,
is
my-
that untainted as well as unsuccessful in 2016 selection process will not be permitted.
No,
If that is accepted,
if this interpretation is accepted, that only the untainted candidates would be given the chance with the age relaxation, then tainted and unsuccessful candidates are also barred.
why unsuccessful
Why not?
be clubbed with
Why not?
with tainted?
Why not? Did we make any inquiry whether they were tainted or untainted? Inquiry was tainted or untainted. They were unsuccessful. Nobody. Kindly see, my lord. Just excuse me. At any point of time, unsuccessful candidates' fate was not discussed because they are not entitled to. If an interpretation is made, I am submitting, my lord. I am submitting that this with appropriate age relaxation means only in the case of untainted appropriate age relaxation. But it is open to all. But it is open to all. But it is, if it is interpreted that only the untainted candidate can make application of that selection process, then accepting untainted, neither tainted nor unsuccessful candidates can make an application.
Only simple question I am asking.
My lord,
In
I will
view-
try to give answer.
In view of the order passed by the Honorable Supreme Court
Oh, yes.
or judgment of the Supreme Court dated 3rd April 2025,
Yes.
read with the order passed on an application dated 17th
Correct,
April
correct.
2025, whether tainted candidates should be permitted to participate in the selection process.
This is your question.
Yes.
I am giving you answer. Come. This is the only question. Nothing more than that. Now, what has happened? All termination. Effect of 3rd July order is a termination. 3rd July, no?
Yes,
3rd April. Sorry.
3rd April.
3rd April, all termination. Tainted, untainted, all termination. Now, from April, there are vacancies. This untainted were not going on in the employment. Then who made an application? Board made an application. Not the state, not the SSC. What they have said, kindly allow us to conclude to make the interview complete. Until that, kindly allow us to continue with this. For which classes? They have made an elaborate application. Now, what the Supreme Court said? Kindly come to page 86 first.
Paragraph?
Page 86 is the order. Let me read this.
No, tell me the paragraph because I am
No, kindly from the top.
order dated.
The order dated, that order what your lordship was referring to? 17th April.
17th April.
April.
Just. Yes, 17th April.
We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10, classes 9 and 12, not found to be tainted, subject to the following condition. We are ready to accept. Prayer for what? Prayer for continuation of their service until the selection process is made. That was a prayer by the board. Now kindly read again. Kindly excuse me. Sorry, my lord.
Yes, yes.
তোমরা এরকম করো কেন বলো তো? We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10 and class 11 and 12 not found to be tainted subject to the following
So that
conditions.
is according to you is this with relation to their continuation
Of service, not for any other
has
reason.
been extended till 31st of December.
Correct.
Yes.
Those who are untainted, let us kindly see group CD they have not given. Group CB also tainted,
To that
untainted.
extent, there is an observation in this.
That's right. Group CB did not. Only for 9 and 10 and 11 and 12. continue with this service. That doesn't mean no, they will continue with this service till doomsday. No, they have to come through a selection process if they continue up to 31st December.
But subsequent directions?
I am coming, Milan. Therefore, this is only for continuation of appointment, not for any other factors. Next, an advertisement for fresh recruitment to the aforesaid posts. Post means 9 and 12. We have not done other, only 9 and 12.
9 to 12, yes.
Shall 9, 10, 11, 12. Subject shall be published before 31st May. We have done it. The examination and the entire recruitment process shall be completed by 31st December 2025. The state government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 2025. Enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule. Therefore, as so as to ensure completion of the recruitment process by 31st December 2025. In case the advertisement is not published and the affidavits are not filed by the court, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Therefore, what are the risks were there? Risks were first risk to us, I mean to the board, that their employment will be terminated if 31st May 2025 is not done.
Whose employment will be terminated?
Those who have got this by this order
31st of December.
up to 31st December. Their service will go. Second risk, cost. Anyway, we have done it. I mean, state done it. 30th rule has been published in the morning. 30th advertisement has been made. Because 31st May was the cut-off date. We have complied with the order. Therefore, my submission kind is similar. Why I am submitting? That's the reason I wanted to say. Give me, I will try to. This may be accepted, may not be accepted. That's a different. Saying about that, no. Tainted have been totally discarded even by 31st May or this order, 17th July. This is incorrect submission. Factual position is this. They will be there. Only untainted candidate service will continue up to 31st. That doesn't mean that the Supreme Court has cut a bar. No, tainted candidates will not be allowed to sit in the examination. Anyway,
After holding that there was an egregious fraud in the matter.
my lord, can I say,
Appointment,
since
can
your
it be accepted, Mr.
Since your lordship have said, let me take it. Since it is a fraud, their appointments have been terminated.
With the direction to refund salary.
No, please. Kindly read this paragraph again. Refund salary to whom? No. কোথায় দাও? Refund salary টা? I am reading it. Paragraph 45. Kindly read. The last question, paragraph 48. The last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the directions of the High Court. The service of the tendered candidates or appointed must be terminated and they should be required to refund any salaries, payments received such their appointments were the result of fraud. This amounts to cheating, therefore we see no aspect. Very nice.
So
Correct. Your lordship is correct.
Yes.
Now,
So thereafter,
Now
they have to
let-
be treated
let-
as a candidate to
let
apply.
me explain. If your lordships read this entire judgment, your lordships will find it has been said that the Evidence Act doesn't apply. Correct. It's an inquiry naturally in a domestic in character. Whole inquiry. Charges have not been proved by anybody. It's a finding on the basis of this reports of the tainted, untainted. Court has not said the charges against them in a criminal court have been established. On the basis of a report on the OMR sheet, tainted, untainted has been given. Now, kindly see the judgment, paragraph 50. Our observation and findings would not influence the criminal proceedings. There was this observation for the temple was for deciding that matter, not for future decision. Why should I not? Is there any conviction? Is there any conviction? Under what law they should be debarred?
Mr. Bandyopadhyay, it is worse than dismissal from service.
Which one?
This observation and
Dismissal. When your lordship has come to this,
which would include
my lord,
future,
kindly see.
future disqualification.
No, kindly this.
Since the appointments were the result of fraud, this amounts to cheating.
Kindly see. Dismissal with no appointment should be given. It should be governed by a rule.
And by making an
My lord.
rules dated 29th of May 2025, this untainted candidates have been permitted again to apply.
Yes,
And they have to get their marks for 10, which
I
has
am
been
coming,
allotted
Lord,
for past service.
one by one. I have to come, Lord. I have to come one by one. First is the dismissal. When it dismissed service cannot get an appointment. If there is a rule, it has not been said dismissed from service, terminated from service. Compulsory retirement and dismissal is not same.
So that's why I have consciously used the terminology dismissal.
Therefore, this order has not been dismissed. Their services are dismissed.
Terminated for cheating and fraud.
Terminated. Cheating and fraud with an observation. This observation will not influence the criminal proceeding. No conviction. There is a single case of no conviction. But this is our submission. Court, whatever the court will say, that's a different thing. That's the different part. This is our reading, we are saying. We have opened the door for all. Let's
How that is permissible in view of this?
why not?
How in view of this order?
Supreme Court has not said. Supreme Court has not said.
And moreover, Supreme Court has not interfered with the judgment of the Honorable Division Bench dated April 2024.
Division bench judgment has been merged with the Supreme Court.
Yes.
Justice Bosak has already made an observation in content petition.
That is marked.
Our observation has been merged
But
with the
Supreme Court has not deviated from the.
No, Supreme Court has but the Supreme Court has not said that the only unemployed, only untainted candidates will be given the chance. Had it been said, I would have accepted this. If it is interpreted, only untainted candidates will get the chance. In that case, neither tainted nor unsuccessful candidates will get the chance.
So what is the difference? If I accept your submission in connection with the observations made by the Supreme Court in paragraph 49, the difference in between tainted and untainted is for tainted, they will not get age relaxation.
Age relaxation.
For untainted, they will get age relaxation.
Why, Willard? I am saying, whole lot will not come.
In view of this, in spite of this observation of cheating and fraud.
My lord, yes, I have to read paragraph 49. I have to go by paragraph 49. What I will follow? I will follow the observation. Direction part I will follow. Whatever the direction is there, I have to follow. I cannot deviate from the directions. I am just following the directions. My lord, kindly excuse me for saying with great respect that if there are two interpretations are there, one of the interpretation, if it's right, that
Now another issue which is troubling this court, Mr. Bandyopadhyay,
my lord.
come to this rules
All right.
dated 29th of May 2025. Rules of dated 29th May.
My lord, prior to that, your lordship,
I will hear you.
just one disqualification I will just show to your lordship. Our rule. Then I am coming. Kindly excuse me. 3.5. Rule,
Page,
rule, rule. you
that's
have-
rule.
Rule.
Yes. Yes, 30th May 2025 is the notification and rule is 29th of May. Just a minute.
3 rules, sub rule 5.
এই ওই যেটা দাও তো এটা থেকে আমি জাস্ট এইটা
My lord, 102. I am told one.
জাস্ট yes 29th May rule
29. No person shall be eligible for 3 Roman 5.
3 Roman 5
These are the disqualification.
yes
No person shall be eligible for selection for appointment unless he is a citizen of India. B. No person shall be eligible for selection for appointment if he is convicted by any court of law.
yes
Conviction, if there is a conviction. My lord, years together, 5 years, 4 years, matter would be kept pending in the criminal cases, and the citizens, boys and children of these people of state of West Bengal will be remain in a limbo condition. Is it acceptable also?
now Mr. Bandyopadhyay please come to schedule 1
Yes, my lord. 108.
then schedule 2 not schedule 1 schedule 2
Till 2. 123. It is still 2. Yes, academic.
then written marks the marks which were allotted previously that has been changed previously it was
Patra niye. Kindly come to me, lord, that written examination OMR.
previously it was 55 plus
Now it has
35
been
plus
increased.
10 now it is 60 plus 10 plus 10 plus 10
60.
now if court proceeds on the premise that it is within the domain of the recruiting authority to frame rules in according rules court will not enter into this issue but what is pinching this court is this
Yes.
come to schedule 1 this prior teaching experience 10
My lord,
please see prior under schedule 2 then capital A1 2A then 2B prior teaching experience 10
yes.
have you found
Yes, prior
Prior
teaching
teaching
experience
experience
10 marks.
so written examination 60 marks then academics 10 marks
Yes.
then apart from 10 oral interview 10 lecture demonstration 10 very good prior teaching experience 10 that these tainted candidates who have lost their job with by the dint of the order of the honorable supreme court judgment dated 3rd of April 2025 with an observation that they are the product of cheating and egregious violations of the law they are to get the benefit of this prior teaching experience
Can I say?
yes
If, my lord, if the question is, once you have tainted, then you can't get any chances in life, then it's a different thing. That you hold it. Once it has been declared tainted, this generation, these people will never get a chance to record it. I don't mind. I will say to that. But according to me, and this 10% rules is not a new one. It was earlier also there, pre-2016.
no I am not questioning
No.
this rule I am questioning that if this tainted
Again, I am-
candidates are to be permitted by submitting application to be considered then whether these tainted candidates are also going to get these marks of 10
My lord, if
for
the
their
de jure doctrine,
experience in
if the de
in
jure
connection with
doctrine,
past service
I hope, my lord, your lordships know that de jure doctrine. Suppose a district judge appointment is dismissed or appointment is held null and void and or cancelled by the judiciary, his judgment will go.
that whether the situation is equated with this
But my lord, I am talking about principle of law.
it's not a similar situation
My
Mr.
lord, I am
Bandyopadhyay.
talking about principle of law.
when the Supreme Court in
I am
paragraph
talking
45
about-
onwards has specifically
My lord,
directed
your lordship hold it. I don't
has
mind.
directed
My lord, your lordship hold it. I don't mind. But I am, my lord, kindly see, let me be very clear to your lordships. I am open to all. It's an open category. Whoever will succeed, whoever will not succeed, they will get the appointment. So far, the age relaxation is concerned, only the untainted candidates will get avail. Neither the tainted candidates nor the unsuccessful candidates will get this chance. all the candidates will not get the chance, as if all tainted candidates are coming. No. Answer is no. Have they given in the petition how many tainted candidates will get chances?
No, anxiety of the court is this, that the order of the Supreme Court has to be followed in its true letter and spirit.
My lord.
Where Supreme Court has said that these benefits are to be granted only in connection with the next selection process, which is confined to the, not in the same language, as it appears that it is confined to the untainted candidates. Then where is the bar you have claimed in your rules or in your notification that tainted candidates will not be permitted?
My lord, I do not read, kindly excuse me, my lord, just with greatest respect, deepest respect to your lordships, my lord, with deep respect to your lordships, my lord, I do not read the lines that the tainted candidates have been debarred to appear in the examinations. Tainted candidates.
Tainted.
I am submitting, my lord, my stand is very clear. My stand is, it is open to all. Open to all. Unsuccessful, tainted, untainted, everyone.
Very well, Mr. Bandyopadhyay.
And
I have noted your submission and any other point.
my lord, and kindly note that if it is said, so far 2016 selection process, only the untainted candidates will avail the opportunity, then tainted and unsuccessful, all are barred.
Yes, any other.
Double punishment, Article 2020, Article 2021. Refund of salary has been made, service has been terminated. Finished. No age benefit. Now, can they not sit in the examination with competition? Only these persons will be benefited. Those who are did not get the chance, because here they are the litigant. Only litigants will get the benefits.
These 2 points you have argued in details.
Yes.
Any other point?
My lord, any other points, means, my lord, I have to argue. If I have to argue to the rules is rule
No,
framing.
regarding I am expressing my mind,
My lord.
so that in order to
My
cut
lord,
short the interview,
Yes.
regarding this allotment of marks and this 40-45% court will not enter. It's a policy decision. Court will not enter into this issue. What is troubling this court is whether the tainted candidates will be permitted to participate or not.
Yes.
That I am hearing you. And please address this court on the point that how far this court can go with in view of the order passed by the Supreme Court on 17th April 2025 fixing time.
But my lord, first of all, my lord, kindly just excuse, since it's a discussion aware, your lordship is finally deciding the matter, or?
Yes, I will finally decide.
Okay. Now, my lord, my submission would be, I have made my first submission regarding tainted and untainted. The court will not interfere. If the court interferes, then the, my lord, that 3rd July, 3rd April order will be interfered with. We will not be able to do it by 31st December, whatever it may be. And the persons who are appointed in view of the Supreme Court's order, they have to go. After 31st December, I cannot.
If the time schedule is extended.
If your lordships can do it, can't do it.
No. Court will not going to extend the time schedule.
Then these questions we will not discuss, because it will be discussed in the Supreme Court. It will be discussed in the Supreme
But certainly court can enter into the arena where court finds that a Supreme Court order is not being complied with in its
Court. Sure. If your lordship strikes up,
entering the time schedule.
my lord, kindly see, if your lordship hold that this rule is bad, your lordship can strike it down. I am not saying that your lordship doesn't have the power. We have been asked to file an affidavit, we have filed the affidavit. There is a proceeding, my lord, pending before the Supreme Court under Article 32 of the petition, challenging the same rules, filed on 10th June 2025. Details proceeding, the petition under Article 32 is, and also an contempt petition has been filed. Whether we have violated the Supreme Court judgment order.
No, but what
the
is-
inquiry which your
what
lordships
court
are
is
making.
thinking that keeping this selection process alive
Mm.
in terms of the time schedule fixed by the Honorable Supreme Court, court can debar the tainted candidates from participating.
Therefore, your lordship invalidating the rule in another way.
In order to maintain, in order to for the purpose of strict observations of the strict compliance of the directions of the Supreme Court.
My lord, that's your lordship. My lord, then in that case, your lordships, if your lordships hold that the
That is what court is thinking.
court is thinking
That without, because court cannot tinker with the, you are absolutely correct, Mr. Bandyopadhyay, that court cannot tinker with the time schedule fixed by the Honorable Supreme Court. And what you have said, that is also to be taken into consideration. If time schedule is extended, then these persons who are untainted and those who are appointed, whose appointments have
if
been
your
extended
lordship,
till 31st, they will lose their job. So therefore, within the parameters of the order passed by the Supreme Court, as well as taking note of the steps taken by the recruiting authority relating to issuance of recruitment rules as well as recruitment notification, court can debar the tainted candidates from.
my lord, kindly, if your lordship doesn't accept my submission,
Yes.
kindly accept one submission that accepting untainted candidates, no one can make the application. In that case, whether tainted or whether unsuccessful candidates.
Accepting untainted candidates.
Whether it is a tainted or whether it is unsuccessful, they also cannot make application. They cannot also make this because their party has not been scrutinized. Scrutinization only for so far that party. If your lordships, kindly excuse me, Miller, if your lordships holds it, although I have a total disagreement, with great respect, I have a
Yes,
disagreement.
that you can always.
I have with great respect, I have a disagreement.
Yes.
If your lordship hold it, that paragraph only gives the chance to the untainted candidates with age relaxation to apply. In that case, neither the tainted nor the unsuccessful candidates also can make the application. If your lord, but I am submitting, it is open to all, only
Your interpretation
That's-
is in connection with
Yes,
paragraph 46.
yes.
We have submitted.
and my lord, in that case, your lordships would be imposing double punishment. Already one punishment, termination, and the refund of the salary has been made. How many times these persons will be victimized? I mean, how many times these persons will be penalized? How many times? Have your lordships have?
If they are the product of fraud and cheating,
They are the fraud of.
they have to face the consequence.
No, fraud and product. That's the reason they have faced the consequences. Therefore, your lordship, if your lordship suggests that no, once you have imprisonment of 3 years, you are not entitled to enjoy any facilities of the society. Does it not violate Article 21 of the Constitution? My submission would be, once they have been tainted, their services have been terminated, they have been penalized to refund their salary, finished, chapter is finished. If they are no age relaxation, if they are eligible according to the qualification, I mean experiences, that the age criteria, they will sit in the examination. Thereafter, another things will be seen. These are my submissions.
Yes.
Only, my lord, I am very limited to your queries, lordship's queries.
No. Whatever I will go to that extent, I have indicated.
I have given the answer. I hope anything is left on. Anything
if I go
is
deep into the matter, then I will.
Of course, anything.
No.
If anything is left for your lordship that I have not given the answer to your queries, your lordship can ask me. I will try to. My point is very clear.
Yes.
My lord, just give me the constitution. Give me one constitution. Just kindly give me 1 second. একজনকে constitution তো আছে আছে। Just give me one. Article 20 of the Constitution first.
Article 21,
Article 20, sub-article 2.
just. Yes, article.
No person shall be prosecuted and punished for the same offense more than once. This is the, my lord, the constitutional philosophy. How a person can be punished for ever, twice, thrice, fourth time? How? Then, my lord, kindly come to 21A. The state shall provide, no person shall be deprived of his life or personal liberty except according to procedure established by law, under which law they are debarred to sit in the examination.
Yes, Mr. Bandyopadhyay.
বললাম তো আমি না না সেটা বললাম তো আমি বলেছি the who cannot sit, that has not been said. If you again please আমি বলেছি দেবাঞ্জন বারবার তোর একটা জিনিস রিপিট করিস I have said I have again, if 40 or 49 paragraph is read to this extent,
Then tainted without age relaxation, untainted with age relaxation.
yes, and only this.
If untainted, and the reverse situation is this, if untainted are to be allowed, then tainted along with unsuccessful are to be excluded.
Excluded.
Yes, yes.
বলে দিস